Welcome, gentlemen. We'll now hear oral evidence from Neil Ross, who's the Associate Director for Policy at Tech UK, and Chris Combemale, I hope I've got that right, Chief Executive Officer of the Data and Marketing Association. Gentlemen, this session, as you've seen from the previous two, has to end no later than 10:50, and I'll be grateful if you'd be kind enough, please, to introduce yourselves to the committee for the record. Mr. Ross.
Thank you for having us before the committee. My name is Neil Ross. I'm the Associate Director of Policy at Tech UK. For your benefit, Tech UK is a trade association that represents the technology sector in the UK, and we have 950 companies in our membership.
Mr. Combemale.
Great, and Chris Combemale, as CEO of the Data and Marketing Association. I have 40 years experience as a practitioner in marketing and advertising, starting at the agency side, including well-known brands, and also leading marketing technology business in first-generation cloud marketing technology.
Mr. Combemale, I apologise for getting your surname.
That's okay, it happens all the time. It's actually a French heritage rather than Italian.
Stephanie Peacock.
Thank you, Chair. Good morning to both the witnesses. Tech UK's response to the withdrawn bill last autumn said that, and I quote, it could go further in seeking the full benefits of data-driven innovation. Does this amended bill go further?
Yes, it does. I think if we go back to the statement given by the Information Commissioner earlier, the most important part of this legislation is to provide increased clarity around how you can use data. In the consultation, I think there was about 3,000 responses to the consultation, and the vast majority of those, particularly around the scientific research provisions and the legitimate interest provisions, focused on providing that extra level of clarity. I think what the government has done is quite clever in that they've lifted examples from the recitals, so recital 157, as well as in relation to legitimate interests, to give that additional clarity on the face of the bill, so that we can take a much more innovative approach to data management and use in the UK, while still maintaining within the kind of the broad umbrella of what would mean that you qualify for EU adequacy.
Okay, great. And have your members found how have they found it adapting to GDPR, and will this bill make it easier or harder for those that you represent to comply?
I mean, most tech companies have adapted to GDPR. It's now a kind of fairly common global standard. I think what this bill does is it means that it makes the kind of compliance burden a little bit easier to use. It allows you to be a bit more flexible in your interpretation of it. And it will give companies much more certainty when taking decisions about data use. One really good example is, for example, on fraud. So we know that online fraud is a massive problem in the UK. The government has a strategy to deal with this. And by having that legitimate interest that focuses on crime prevention, but also those kind of further processing rights around complying with the law, means that you can be much more innovative and adaptive about how you share and process data to detect and prevent fraud. And that'll be absolutely vital for addressing, I think, a shared objective we all have for reducing online fraud.
Thank you. And with regards to the changes to requirements to report suspicious activity related to unsolicited direct marketing, do the telecoms companies amongst your members have the technical capability to identify instances of mass unsolicited direct marketing in order to report these as the bill requires?
No, so this is one area we think further work is needed in the bill. I think you're referring to clause 85. When we responded to the consultation, we said that the government should try to kind of create an equivalence between the privacy and electronic communications requirements and the GDPR to give it that extra level of flex. However, by not doing that and not kind of setting out specific cases where telecom companies have to identify sort of unsolicited calls, it's really unclear what they're being asked to do. And actually we've had concerns raised by a range of companies, both large and small, that they might not have the technical capability, they'll have to set up new systems to do it. So overall we think the bill is a bit of a misstep here, and that we need to clarify exactly how this is going to work. And I think Tech UK and some of my colleagues will be sending some suggested legal amendments about how to do that to the committee.
Okay, and do you think, on this point, do you think the telecoms companies feel they've been properly consulted in the making of this legislation? No. Okay, thank you.
Not on that clause. I think in relation to the rest of the legislation.
No, I was asking
yes.
on that.
Yeah, on that clause, no.
Okay, great. And then just to Chris, will the changes to the cookies set out in this bill benefit firstly the consumer experience and secondly your members or businesses?
Yes, I think first on the consumer experience, I think we all recognize that the pop-up consent banners for cookies are generally ticked as a matter of course by consumers who really want to go about the business and get to the website that they want to do business. And in a way, it's not genuine consent because people really aren't thinking deeply about it. And in terms of business, a number of the cookies, which are really identifiers that help you understand what people are doing on your website, a number of the cookies are used just on a first-party basis for websites like e-commerce websites and business-to-business websites to understand the basic operational aspects and statistical measurement of how many people are going to which pages. And those are websites that don't take any advertising and don't share any data with third parties. So the exemptions in the bill generally would make those types of companies no longer need cookie banners while providing no risk to the customers because they're used purely for a company to understand the behaviors of its own website traffic and its own customers. So in that sense, I think we support strongly the provisions and the exemptions that have been put into the bill.
Okay. Is the technology available to centralize cookies by browser?
I think it can be eventually, but we oppose those provisions in the bill because what they do is they create a market imbalance and give control as a gateway to large companies who manage browser technology at the expense of media owners, publishers who are paying journalists, who are investing in content. And it's incumbent upon all else that media owners are able to develop first-party relationships with their audiences and their customers in order to better understand what they need. So I think, if anything, we need more control in the hands of the people who invest in creating the content and who invest in paying the journalists who provide those important democratic functions.
So there is a concern in centralising cookies by browser, it will entrench the power in the hands of the sort of larger tech companies who own the browsers.
I think it certainly would give even greater market control to those companies.
And is the risk in centralising cookies by browser that we could confuse liability? So, for example, who is responsible for any breach of cookie regulation?
I think it could be. I mean, for us, the essential principle is that a business, whether it's a media owner or it's an e-commerce business or it's a publishing business, that it should have control of the relationships between its products and services and its customers and its prospects for customers. So by nature, I think when you give control to a third party, whether it's a large tech company or other, you're getting in between the relationship between people and the organizations they want to do business with and giving control to an intermediary who may not understand. So at least point, if you register with a website after, for instance, your browser setting, that should take precedence over the browser setting. So your choice to engage with a particular company should always take precedence over a centralized cookie management system.
If I might sort of jump in there. I think what the government has done in relation to this is quite clever in that they've sort of said their objective is to have a kind of centralised system at the future. But they've recognised that there are a number of different legislative and regulatory activities going on which would have a significant bearing on that. I think it was only last week the government introduced the Digital Markets Competition and Consumer Bill, and in the sort of Section 20E of that and the kind of conduct requirements, that would play a large role into whether you could set up a centralised system. So there's an element of kind of coordinating two different but ongoing regulatory regimes. So I think we agree with Chris, which is the steps on analytical cookies now are good, but we need to have a lot more deep thought about what a centralised system may or may not look like, whether we want to go ahead with it.
And if I could just come in on that one final point, is what does make sense to us is centralized systems for managing opt-outs as opposed to managing consent. We, as the Data and Marketing Association, operate the telephone preference service and the mailing preference service, which gives consumers, people, the opportunity to opt out from receiving unwanted cold calls or unwanted direct mail. And there is already a system in place with digital advertising where there is an icon where people can opt out from the use of personal data for personalizing the digital ad. So I think it makes sense if people don't want to receive certain things that they can opt out centrally. But I think a centralized consent opt-in gives too much control to the intermediaries.
Thank you. Thanks, Chair.
Minister.
Thank you. Can I ask Mr. Ross, I know that Tech UK has been supportive of a number of elements of the bill, but particularly around the opportunities created by the use of smart data. And I just wonder if you'd like to set out your view of the opportunities that exist and how this bill will help obtain those.
Yeah, so smart data is a potentially very powerful tool for increasing consumer choice, lowering prices, and also giving people access to a much broader range of services. The smart data provisions the government itself, as well as the Smart Data Council it's leading, are really welcome initiatives. I think, however, what we need to do is go that one step further and start to give people and the industry's clarity around where the government's going to look first in terms of what kind of smart data provisions you might look at, what kind of sectors you might go into. Because ultimately we need to make sure that businesses are well consulted, there's a strong cost-benefit analysis, and then we need to move ahead with sort of key sectors we want to push forward on. So again, similar to on nuisance calls, we'll be sending some suggested text to the committee just to add those bits in. But absolutely, it's a really welcome step forward.
And which particular sectors do you see as offering the most opportunity?
I think, so I don't want to sort of name specific sectors at this point. We're having a lot of engagements with our members about where we'd like to see it first. I think transport sector is one area where it's been used in the past and could have a potentially large use in the future, but it's something which we're exploring and working directly with the government through the Smart Data Council to try and identify those initial sectors we could look at.
Thank you. And Mr. Combemale, I mean, your organisation, can you just set out some of the obstacles that exist at the moment and how you would like to see this bill try and reduce those?
I think the single biggest one that has troubled our members since the implementation of GDPR is the issue around legitimate interest, which was raised earlier by the member from Folkestone. And the main issue is that GDPR contains 6 bases of data processing, which in law are equal. For data and marketing industry, the primary bases are legitimate interest and consent. And it has become widely accepted for some reason through implementation of GDPR that GDPR requires consent for marketing, requires consent for community activities. I'm sure you hear in your constituencies many community groups who feel that they cannot go about organizing their local events because they must have consent to communicate. And that's never been the intention of the legislation. In fact, legitimate interest as a concept, the European Court of Justice has always ruled that any interest that's a legal interest could be a legitimate interest, including advertising and marketing. And if you look at what we do, which is effectively the activity of finding and retaining customers, the legislation, GDPR and Recital 4, says privacy is a fundamental right, not an absolute right, and must be balanced with other rights, such as the right to conduct a business. But you cannot conduct a business without the right to find and retain customers, just as you can't run a charity without the right to find donors who provide, and volunteers who provide the money and the labor for your good cause. So I think the clarification on 6.1m is really important across a wide range of use cases in the economy, but particularly we think ours. And it was recognized in GDPR and Recital 47. And what the legislation does is give illustrative examples that are drawn from the recitals 47, 48, and 49. So they're not new examples, they're just given main text credibility. But it's an illustrative list, and really any interest that's a legal interest could be a legitimate interest for the purpose of data profiling, subject to necessity and proportionality, which we discussed earlier with the Information Commissioner.
Thank you.
Thank you, Chair. We've been hearing already this morning that there are a number of words and phrases that could have some ambiguity associated with them. We've heard the words excessive, and when we're talking about cookies, we hear about where this bill allows certain cookies if they are low risk. Do you think this phrase low risk is well enough understood?
Should I take this? I think for us, in the context of the sector that I represent, we have a fairly clear understanding of the gradients of risk. So as I was saying earlier, many companies don't share data with other companies. They are interested solely in the relationships they have with their existing customers or their existing prospects. And in that sense, all the customer attitudes to privacy research that we do indicates that people are generally comfortable with sharing data with companies that they trust and that they do business with regularly. So I think first party...
So would that then be the definition of low risk?
I wouldn't want to suggest what the legal definition is. In our understanding, existing customer relationships, because you have loyal customers who trust the brands and who sometimes are passionate about the brands that they interact with. I think to us in direct marketing and data and marketing, that's low risk. Higher risk is when you come to sharing data with other companies, but again, much of that activity and data sharing is essential to creating relevance. So again, with the right protections, not a hugely high risk activity, and then you can move on up where the higher the degree of automation, the higher degree of third-party data, the greater the risk, and then you have to put in place mitigations accordingly. So I'm not a lawyer, I'm just a poor practitioner, so I can't define from a legal point of view, but I think it's clear within the context of our industry how risk elevates depending on what you're doing.
I'll maybe come back to that in a second, but I think Neil wanted to add
Yeah, I was going to say, you can see sort of how Chris has interpreted it in the lens of his industry, how the feedback that we've had from our members who operate across a range of industries is actually there's quite a lot of confusion about what that terminology might mean. And if the rest of the bill has aimed to clarify elements of the GDPR and put them on the face of the bill, this particular provision seems to be going sort of the other direction and raising concern and confusion. And that's why we've always taken an approach that if you try to align Pecker more with the GDPR, which does have clear legal bases and processing and understanding of what's high and low risk, a balancing test, etc., you're going to get much more clarity that way rather than through this kind of fairly broad and ununderstood term of low risk. So we have concerns about how it operates across a range of sectors.
And it's interesting, Tracy, you said you're not a lawyer and you can't define what low risk is, but there will be, of course, there will have to be some sort of definition of what low risk is. Have we captured that well enough then?
I think coming back to what we were discussing in terms of legitimate interest and the proportionality balancing test, or legitimate interest impact assessments as they would be called, when you're thinking about what you're doing with your customers and what you're planning to do, it's a requirement first of good marketing anyway without the legislation, but also within the legislation to think about what you're planning to do and how it might impact your customer's privacy, and then to mitigate. So I think the important thing is not to say there's no risk or low risk or high risk. The important is the higher the risk, the greater the mitigations you have to put in place, and you may conclude that you shouldn't do something because the risk level is too high. But I think that's what balancing tests do, and decisions and outcomes that result from balancing tests.
The difficulty is here potentially is that you're putting the responsibility has been put on the company. What you've described as a responsible company who is categorising different levels of risk and taking different actions accordingly, without a clear definition. If this was a less scrupulous company, would there be a grey area?
Well, we do a lot of work combating rogue traders and provide evidence to cases from our work at the Telephone Preference Service and other activities. And, rogue traders, especially those with criminal intent, are going to generally ignore the legislation anyway, regardless of what you do. But I think you're right, whether it lacks clarity. But I think an important part of GDPR is that it does put a lot of responsibility on companies to consider their particular activity, their particular customer base, the nature of their audience. If you're Age UK, a charity that has a lot of vulnerable elderly customers, you have to put in place greater protections and thought into how you're doing things than if you're potentially, a nightclub marketing to under 30s who are very technologically literate and digitally conversant. And when we do customer attitudes to privacy studies, we can see three broad segmentations of data unconcerned, data pragmatists, and data fundamentalists, and they require different treatments. So part of what's incumbent on any company from a marketing context is to understand who your audience is, who your customer base is, and to design programs appropriately so that you build trust and long-term relationships over time. So I do think it's an important element of GDPR from a marketer's perspective. And really, it shouldn't take legislation to force marketers to do that, I should add.
5 minutes left. 2 members seeking to ask questions. Damien Collins.
Thank you. Just wanted to ask with regards to children's data rights and the age-appropriate design code. Do you think the bill will have any implications for the way in which the age-appropriate design code has been implemented by companies working within it at the moment? It's not sort of expressly written into the bill. Would you expect any change?
No, I don't expect so. I think given some of the exemptions for further processing, it might help improve compliance with the law, because compliance with the law in a public interest is then a basis on which you can process data further. So it might make it easier for companies to implement the age-appropriate.
Could you give any examples of that?
Just kind of giving you additional clarity on when and where you can use data on various grounds. There's a wide range of circumstances which you can run into in implementing the age-appropriate design code. So having more flexibility in the law to know that you can process data to meet a legal objective or for a public interest would be helpful. I mean, the best example I can give is from the pandemic, actually, where a lot of the time government was requesting data from, in this case it was telecoms companies, but others, and they were really unsure of what their legal basis was for sharing that data and processing it further in compliance with a kind of a government or a regulatory request. And this bill takes significant steps to try and improve that process.
So, could you give an example more directly related to children?
I don't have one to hand, but we can certainly follow up.
Thank you.
Mike Ainsbury.
Yes, the bill enables the Commissioner to impose a fine of £1,000. Is that a reasonable deterrent at that level?
And this is in relation to clause 85 on the nuisance.
For non-compliance?
Yes. We don't really think it's particularly appropriate for this scenario, given that the telecoms operators are just, informing the ICO of activity that's happening on their service. It's not that they are the bad actors in the first instance, and they're having to manage it. So, I mean, ultimately the first step is to clarify the aims of clause 85, and then whether a fine is appropriate or not is a kind of a subsequent question.
Yes, I mean, some companies would be small fry, won't it, £1,000 really?
It will vary from company to company. I think you obviously want some form of most companies will always seek to comply with the law, and if you feel you need some kind of deterrent, that's something for Parliament to consider. But I think the first step is to make sure that the law is really clear about what's asking companies to do, and at the moment that's not the situation we're in.
Okay.
2 minutes left. Last question, Chiomura.
Thank you, Chair. So, Mr. Combemale, you set out some of the challenges of having centralised, if you like, cookie management, and how that would give more power to the browsers and to the devices. What you didn't set out really was how we could give more control and power to customers, citizens, how they use their data. What are you doing to ensure that consumers or customers, people, have more control over how their data is used? Apart from you talked about the little thing that you can click to stop personal data being used. Actually, that's been in there for some time now. It's great, but what are you doing to ensure to give people more control? And Mr. Ross, if you have the time, what is your sector doing? Because the technology should be there to help and empower people.
Yeah, I think a lot of what our sector does voluntarily, setting aside the legislation, is the creation of what are called permission centers, and you'll be familiar when you go to websites and they ask, categories of information or products that you're interested in doing. So I think that allows consumers to express their interest. And I think you also have within the legislation very clear data notification that's required at the point that you collect data that requires companies to tell you what you want to do, and whether it's consent or legitimate interest, consumers always have the right to opt out. And when it comes to marketing, there's an absolute right to ask not to receive marketing of any kind, whether it's email, direct mail, telephone, at any time, and companies have an obligation to follow that. So I think when it comes to marketing, which is my subject matter expertise, consumers are very well protected and do exercise their rights to opt out. They're further protected by central services, like I mentioned, the telephone preference service, which is a law that companies look up against, and 70% or so of households have registered their telephone number there. So I think there are a large number of protections in place, both through the legislation and voluntarily.
Mr. Ross, 30 seconds.
Okay. I would say there's been a big drive among many tech companies to kind of be better, to explain better how they use and handle data practices. So there's a kind of drive within the sector to do that anyway. Some of that has come from legislative and regulatory activity, for example, the Online Safety Bill and other places. One thing I would say about this legislation, where it does have the opportunity to give people more control over data, is through the privacy management frameworks. So by taking a less sort of strict tick box approach to data handling practices, there's the opportunity for whole sectors or for interest groups like trade unions to kind of put forward what their ideal